So first of all, I want to outline to you two models of how registered intellectual property rights operate that you may well be familiar with. The conception of intellectual property rights as fence posts, or registrations as fence posts, or registrations as signposts. And then I will try and take you through some material on the registration of trademarks that implies that the model of registration is the fence post model. The argument will then proceed to look at case law on infringement of trademarks and suggest that in contrast here, rather than the registration operating as fence posts, we actually see that the trademark system has a conception of the property in a trademark that is different from the property in the terms of the registration, so that the registration is better seen as operating as signposts rather than fence posts. So that leads to a question. If at the registration stage we conceive of trademarks as trademark representations as fence posts, but at the infringement stage we abandon the representation as fence posts and just rely on them as signposts, what's going on? How can we understand this? And I want to propose two ways that we can understand this discontinuity in the logic of the trademark system. One is through the distinction between subject matter and extent or scope of protection. And the second is through a distinction in the system between used and unused trademarks. And then finally, I want to raise some questions about what the implications might be of recognizing the European Union's trademark system as actually bifurcated into two systems. One which protects unused trademarks through registration, where the property is determined through a fence post model, and the other through a system for protecting used marks, where registration functions merely as a signpost and the property is defined through a number of factors that are external to the registration system. So that's the plan. Now, if you didn't understand any of that, hopefully what I'm going to say will elaborate. And a key to what I'm going to say is this basic distinction between fence posts and signposts as models of property definition. And this comes from the field of patents, really, where there have long been debates about the way in which patent claims should operate or do operate within the patent systems, and in particular, how claims operate within the European patent system, the European Patent Convention. And so the language of fence posts and signposts, I think, comes from Professor Cornish, who in the 1970s was writing about precisely this issue. So in the fence posts model of patent law, you have the claims, the pithy statements that feature at the end of the specification, after the description. This description teaches the person skilled in the art how to perform the invention, and the claims at the end identify the property very precisely for which protection is sought. So in the fence post model, the scope of protection is determined by those claims, and they are drafted with that very goal in mind, and you have to be extremely skillful to draft patent claims. So what the register is doing here is not just indicating that protection is claimed by the patentee, but it is indicating what is claimed. So we see the claims function as fence post. That model of property definition in claims in patent law is very strongly associated with the British tradition of patent claiming. In contrast, there is another tradition in patent law, where claims function as signposts. The claims feature after the description and say, this is what I think the essence of my invention is. So the claims then operate as a starting point for defining the property, but not the end point. And so in Cornish's terms, they are a sign pointing you in the direction of where the property is. But to find out what the property is, you have to investigate closely what the achievement of the inventor was compared to what was already in the state of the art. So the claims function then to signal that something is claimed, to point in the direction of what it is, but not to determine precisely the peripheral boundaries of the property. So the question arises, with this model of property in mind, what sort of system is the EU trademark system? And I think that when you look at the various materials that relate to the registration of EU trademarks, so I'm thinking here of the regulation, of the implementing regulations, of the guidelines from the EU IPO, of the case law of the Court of Justice of the European Union and General Court, and of the commentaries. The model of property that they foresee is a model where the trademark registration functions as fence posts, where the two parts that define the mark and the parts that define the goods or services in relation to which the mark is going to be used, operate to define the outer limits of the property. This is a peripheral claiming system, it seems. So in defining the mark, there are three elements that are recognised. The representation, by far the most important component, which would be in a word mark, what the word is. In a figurative mark, usually a visual image of the word or device or combination as presented, etc. In some cases also a description. A description is utilised in cases where the representation is usually of some unusual type of trademark, like a position mark. So you might have a representation of the position mark showing where on a particular product the feature that's said to be the trademark occurs. So, say, if we were claiming orange-toed socks as a trademark, we might have the image of the sock with the orange toe, and then the description would supplement that to explain the nature of the representation. And in addition, we have also an indication of the type of mark. And the EU trademark system, as currently reformed, recognises these 10 different types of mark for which it prescribes certain special criteria. Word marks, figurative marks, shape marks being familiar ones, and then these more unusual ones, position marks, pattern marks, colour marks, sound marks, motion marks, multimedia marks, and hologram marks. In addition, an applicant for an EU trademark must identify the goods or services for which it seeks protection, and this is done in the specification. I'll come back to that in a moment. Now, these regulations reflect the basic requirement in the legislation itself, Article 4, that the trademark be represented graphically. Sorry, the trademark be represented formally graphically until October last year, but now represented in any manner, not merely graphically, in such a way that enables competent authorities and the public to determine the clear and precise subject matter of protection afforded to its proprietor. And so you see now within the primary legislation itself, the requirement of representation be clear and precise, and to enable the public to determine the protection afforded to the proprietor. And you also see in recital 10 there a requirement that the representation satisfy seven requirements laid down initially by the Court of Justice in the Siegmund decision, that the representation be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. Now the regulations go on to reiterate this, the implementing regulations go on to reiterate it, and I'll just draw out again the same sort of language. The representation must enable the competent authorities and the public to determine with clarity and precision the subject matter of protection. And then there are certain provisions, again in the implementing regulations, echoing the primary directive about the requirements of the representation. Now, the requirement that the representation be self-contained importantly suggests that when you are deciding what the mark is, one thing that is largely irrelevant is how the mark is used in practice. It is the representation that determines the mark of the subject matter and in turn the scope of protection. And Curley, which is one of the British texts on trademark law, emphasises this in its commentary on the new rules, the 2017 rules. It's clear that these detailed rules have been constructed with some care. They are designed to ensure that it is not permissible to interpret the representation by reference to any product which may be on the market. So the product on the market is something different from the representation, and it's the representation that defines the subject matter and therefore in turn the rights. Equally for the goods or services, we have requirements in Article 33.2 that the application define the goods or services with sufficient clarity or precision to enable the competent authorities and economic operators on that sole basis to determine the extent of protection sought. So once again, we see that the model of registration here in regard to the goods or services, previously with regards to the representation, requires clarity and precision, and the clarity and precision is designed to determine the extent of the protection sought. So a fence post notion, again, of protection. One second. Okay. So, we've seen what the requirements are that the representation and the specification define with clarity and precision the subject matter and the extent of protection. The commentaries tell us something about the goals behind all this. So one commentary by Gregor Schneider says the requirement, he's talking here about the representation requirement, aims at legal certainty. A registered trademark grants to the owner a monopoly, the scope of which must be precisely defined. So we're defining the monopoly. By inspecting the register of trademarks, it must be possible to know the nature and scope of the signs registered as trademarks. Similarly, Curley, the text I just referred to, says that the requirement that a mark be capable of being represented arises from important practical considerations concerned with certainty. First, the Trademark Office must know with certainty what is comprised in the sign. Secondly, and of greater importance, other traders must be able to ascertain with certainty exactly what their competitors actual or potential, have registered or have applied to register. So we have these requirements of clarity and precision, and we start to see from the commentaries that these are about determining the extent of protection and affording certainty to competitors in the marketplace so they can know precisely what has been protected. And these views of commentators in turn reflect the sorts of things that have been said by the Court of Justice in a bunch of cases concerned with interpreting the graphic representation requirement, but now equally of relevance in determining the function of the representation requirement, now that graphic element of that is no longer pertinent. So in Siegmund, which is a case that you'll all be familiar with, where the applicant sought to protect the smell of cinnamon as a trademark, and the Benelux trademark office made a reference to the, or maybe it was the German one, made a reference to the ECJ. The ECJ considered the graphic representation requirement as it then was, and laid down some important indicators of its functions. Paragraph 48, the function of graphic representability is to define the mark itself in order to determine the precise subject matter of protection afforded by the registered mark to its proprietor. Okay, this is feeling very fence posts. Next, the entry of the mark in a public register has the aim of making it accessible to competent authorities and the public, particularly to economic operators. Economic operators must, with clarity and precision, be able to find out about registrations and thus to receive relevant information about rights of third parties. This reflects the views of Advocate General Colomer, which are rather more elaborate. The requirement is imposed for reasons of legal certainty. By inspecting the register, it must be possible to know to the full extent of the public nature of registers the nature and scope of the signs. The symbols so claimed must be known very precisely so that other people may be properly guided. The registration must be complete, clear and precise so the object of the right of exclusivity is immediately clear. And also in Heidelberger Boschemi, case concerning an application to register two colours in multiple forms, which the Court of Justice indicated would not be an acceptable mode of graphic representation. The court said, and I'm just going to go to paragraph 35 here, the representations proposed would allow numerous different combinations and would not permit competent authorities and economic operators to know the scope of protection afforded to the proprietor of the trademark. Now, I'm beating you over the head, and I'm going to beat you over the head a little bit more. I've been beating you over the head with regard to the representation. And you can see from all this that is clear that the legislation requires clarity and precision, and that the courts and commentators indicate the purpose of that, and the purpose of that is very consistent with this idea of the representation being the outer bounds of the property, and other people needing to know what the outer bounds of the property are and the crucial part of the representation in that. But we also see the same thing in relation to the specification. We've seen the new language about the clarity and precision of the specification. And that reflects Court of Justice case law, in particular the IP translator decision, where the question before the court was whether the class headings in the NIS classification system could be used by an applicant, and if so, whether use of the class headings in the NIS system was to be interpreted as covering all the items in the particular class. And the Court of Justice rejected the idea that use of all the class headings could be interpreted as a reference to all goods or services within the class. And in so doing, it emphasised, in language borrowed from Siegmund, precisely the same goals of the representation requirement. Article 49. The directive requires goods and services for which the protection of the trademark is sought to be identified by the applicant with clarity and precision. Why? To enable the competent authorities and economic operators on that basis alone to determine the extent of protection sought. So, nice to see you. So you can see now that in terms of the application jurisprudence, legal material surrounding it, there is a general sense that the goals of the registration are to provide the fence posts to the property. So I wanted to make two minor points, which are really asides. These aren't part of the general thesis. The first is that in deciding whether a representation is sufficiently clear and precise, whether it provides the necessary certainty, it is very important for students or participants in the system to appreciate the important role of conventions, because conventions in fact operate to say some things are clear and precise and other things are not. And if you have agreed conventions, then people can use those conventions in order to make sure their applications satisfy the criteria. So, for example, word marks. Everybody accepts that you can register a word mark just by providing the word in a particular standard type. At the same time, it is a basic premise of the system that a word registration covers all words, no matter what colour, all instantiations of that word, no matter what colour or figurative representation. That is a convention. Okay, so that the word covers all forms of the word, whether in different fonts, in different styles, different colours. But the word itself is regarded as sufficiently clear and precise. Equally with figurative marks, there have been different conventions in different member states about registering in black and white. For a long time, it was thought in the United Kingdom that registration in black and white conferred on the trademark holder protection in all colours. So if you register a Nike swoosh device in white against a black background, that covers the use of that device against any colour background, or indeed in any colour against any contrasting background. In contrast, the Court of Justice's view in relation to community EU trademarks is that a registration that is in black and white means black and white. What they like to say is what you see is what you get. So they don't operate a convention, whereas the British system had operated a convention. And so there were different approaches to this issue. Now the effect of requiring a what you see, what you get approach is that an applicant would want to register a multiplicity of versions of the same mark in different colours to get the same protection as they formerly would have got under convention that black and white meant any colour. So this is just to highlight that clarity and precision don't exist by themselves. They exist in a world where there are certain conventions, and that it is important for those conventions to be clear and well articulated. Another convention in relation to position marks is that the use of dotted lines indicates goods that are relevant to the mark being claimed. And this is a convention that's derived from both patent law and indeed from design representations. And there is a potential convention, I'm not sure whether it is a convention because I'm not absolutely certain what the rule would be, in relation to sound marks, that if you represent a sound mark by using a stave, a treble clef and crotchets and quavers and so on, that would cover the sound made by whatever instrument, even though they would be very different sounds if made by different instruments. So that's the first aside. The second aside flows from that, is that the Court of Justice and the legislation keeps telling us that we need clarity and precision. But as we well know from practices of legislative drafting, clarity and precision are not the same thing. And sometimes adding precision has the effect of removing clarity. So a classic way to add precision is to have lists and lists and lists of things that would be covered. But if you have lists and lists of things that would be covered, that effect is often to make the legislation much less clear and much less intelligible. So one effect of the conventions between black and white marks, and Britain has now moved from its old convention that black and white meant any colour to the EU position that black and white means black and white, is that it will produce a proliferation of applications of marks in multiple colours. So you will have more precision because you've abandoned the convention. But whether you will have more clarity about what it is that is really being protected is less clear. And so Curley tells us that wealthy traders avoid the problems caused by the changes in convention just by registering multiple marks, and that perhaps is unsurprising. Okay, so that's, I hope, established for you this idea that trademark registrations, the representation side, the specification side, are to operate as fence posts. Now what I want to suggest is that when we move to different parts of trademark law, this fence post model of trademarks suddenly vanishes. Or, if not vanishes, becomes much less prominent or determinative than it had seemed to do in the earlier jurisprudence. And what I want to do is to look at the case law on infringement of trademarks and what that case law says, and to highlight that whether there is infringement of a trademark, in fact, depends on a whole number of things that are not to do with the mark itself. They're not to do with the graphic representation. They depend on acquired distinctiveness, how the mark is perceived in the marketplace. They depend on reputation. They depend on context. And of course, in redefining the specification, they depend on what the mark has been used in relation to. And the thesis is that when you start to look at this area, the trademark registration no longer appears as fence posts. It now appears as a signpost, a starting point, a mode of central claiming rather than peripheral claiming. So this is just a quick reminder of the provisions we're going to be looking at. These are the infringement provisions under the EU TMR, Article 9.2, and you'll all know that there are three ways in which a person can infringe a registered trademark, an EU registered trademark. The first under A is so-called double identity, where the defendant is using a sign which is identical to your sign, and they're using it in relation to goods or services which are identical to those for which you have registered your mark. double identity. Secondly, there's the situation where the sign is identical or similar to your mark, and the goods or services are identical or similar, and the effect of the person's use of the sign will be that there's a likelihood of confusion. We call that confusing similarity. And then under C, under Article 9.2c, we have the situation where the sign is identical or similar, the goods or services may be identical, similar, or not similar, but the earlier mark has a reputation and the use by the defendant will take unfair advantage or be detrimental to the distinctive character or repute of the trademark. And what I want to highlight is that although some case law points to the importance of the trademark as registered, in fact, there are many other factors that go beyond the trademark as registered in determining whether there would be liability. So the starting point is references to the trademark as registered, to the fence post model. And it would be wrong for me to present this as if there were none, as if there was no thought that the representation of the sign mattered. And a good example is the Castel Blanche case concerning Cristal Champagne in the General Court. And there the court said, in considering confusing similarity analysis, the comparison must be made between the signs as they were registered or as they appear in the trademark application, regardless of whether they are used alone or with other marks or mentions. So in that case, Cristal was suing Castel Blanche, and Castel Blanche said, well, actually, Cristal, you use this mark in combination with Louis Roederer and with LR, etc. You don't use it alone. And so we need to make the comparison not between Cristal as registered, but these other items. And the General Court is saying no. The comparison here is between Cristal, the mark as registered, and the defendant's application, Cristal Castel Blanche. And so we see there very much the fence posts model. And in their commentary, Annette Koer and Martin Zenfleben, in their recent commentary on the EU trademark regime, they reiterate that as a matter of principle, the similarity of conflicting marks must be assessed on the basis of the mark as registered or filed for registration. If the form of mark is actually used on the market differs from the registration, this is primarily an issue for requests that the mark be revoked for non-use. Having said that, and acknowledged that that case law exists, most of you will know that when you assess whether there is confusing similarity, the Court of Justice has told us over and over again that you carry out a global assessment. And this global assessment involves consideration not just of the mark as registered. So we see this in the two key cases in which the global assessment approach was adopted in the late 1990s, the Sable and Puma case, and then the Canon and MGM case. And Sable and Puma really defined the criteria for determining whether marks were so similar that there was a likelihood of confusion and the likelihood of confusion standard. And the Canon and MGM case went on and considered when goods are so similar that there's a likelihood of confusion and how you carry out the comparison between the goods as registered and the goods as used by the defendant. So in Sable, what does the court say? Well, Sable concerned two marks that related to leaping felines. And the court was asked for guidance in determining whether these two marks that concern leaping felines were similar. And it laid down the standard approach. You compare them visually orally, and conceptually. And you decide, looking at them as a whole, paying regard to their dominant and distinctive elements of each mark, whether they are similar from those three different perspectives. But it went on in paragraph 24 to add for the possibility that likelihood of confusion would differ depending on how the marks were perceived in the marketplace. And he said this: in that perspective, the more distinctive the earlier mark, the greater will be the likelihood of confusion. It is therefore not impossible that the conceptual similarity resulting from the fact that the two marks use images with analogous semantic content, both were leaping felines, very different looking leaping felines, but still leaping felines, may give rise to a likelihood of confusion. Where the earlier mark has a particularly distinctive character, either per se or because of the reputation it enjoys with the public. So suddenly we see that when deciding whether two marks are so similar that there's a likelihood of confusion, we're not concerned merely with what's on the register and whether it looks, sounds, or is conceptually similar. We're also concerned with how much reputation that mark has developed with the public. And the same occurred in Canon. In Canon, as I told you, they were primarily concerned with the question of similarity of goods. But the court reiterated that the similarity of goods goods or services could be more dissimilar, and there still be a likelihood of confusion where the earlier mark had a high level of distinctiveness. So it says this: furthermore, the more distinctive the earlier mark, the greater the risk of confusion, since the protection of trademarks depends, in accordance with, on there being likelihood of confusion. Marks with a highly distinctive character, either per se or because of the reputation they possess on the market, enjoy broader protection. It follows that for the purposes of the directive, registration of a trademark may have to be refused despite a lesser degree of similarity between the goods or services, where the marks are very similar and the earlier mark, in particular its reputation, is highly distinctive. So the key point here is that the registration system no longer determines the scope of protection. It's no longer giving the fence post, because to know the scope of protection, you need to go outside and understand the reputation that the sign has acquired in the marketplace. And it's only with the benefit of that understanding from the marketplace, and indeed its understanding as distinctive, that one can determine whether there is infringement. The same issue arises in relation to families of marks. Now, the Court of Justice has recognised that the comparison between marks for the purposes of infringement starts off as an individual comparison. You compare the mark as registered with the defendant's mark as used. But the claimant may have registered a number of similar marks as part of a family, and that the global appreciation approach means that if the defendant's mark appears like it would be an extension of that family, it can be regarded as similar to the marks conceived as a family. So the Court of Justice, in this case, Il Ponte Financiera, the Bainbridge case, it recognises the possibility that the comparison is not just mark, registered mark for sign as used, but registered mark as part of a family of marks versus sign as used. But it goes on to say importantly, that that's only the case, and this is paragraph 64, where the family of marks is present in the marketplace. So if the family of marks is merely paper registrations, the family of marks doctrine does not apply. But if it's not merely paper, but it's in the marketplace, then in those circumstances, the extent of protection afforded to each of the family of marks is in some sense greater. So the important point of the family of marks doctrine is that it only applies where the marks are present on the marketplace. The registration system is not telling you of itself what the scope of protection will be. It is functioning to point to the possibility of protection, but requiring you, as a potential defendant, to investigate the marketplace to find out whether there is in fact a family there. Perhaps the case that most well illustrates this idea that trademarks, the trademark representation, is a signpost rather than a fence post, is the Specsavers case. And the Specsavers case was a reference from the English and Welsh Court of Appeal to the Court of Justice. And you can see on the left the Specsavers mark. It was this black 2 overlapping ovals mark in relation to optician services. The mark that it in fact used was a green-coloured mark, often with the words Specsavers in white superimposed. And the defendant's mark, in this case, was Asda Opticians, here on the right, also in light green. Now, if you took the fence posts model seriously, what you would be comparing would be the 2 black overlapping ovals with the 2 white non-overlapping ovals with the words Asda Opticians and the green background. Okay. But the Court of Justice tells us that that's not what you do. You don't compare merely the black 2 overlapping ovals with the light green Asda Opticians. Rather, you can take into account, or indeed you must take into account, the manner in which the mark has been used in the marketplace. So paragraph 37, and I think this is a crucial paragraph for my thesis. At the very least, where there is a trademark which is registered not in particular colours or characteristics, but in black and white, the colour or combination of colours in which the trademark is later used affects how the average consumer of the goods at issue perceives that trademark, and it is therefore liable to increase the likelihood of confusion or association between the earlier trademark and the sign alleged to infringe it. So the Court of Justice has already told us that when you look at a black and white mark, that doesn't mean a mark in any colour. But they then say that this black mark, when it has been used in a particular colour, such that the public has come to associate it with that colour, at that point, in the global appreciation of confusion analysis, you take into account the specific way in which the mark has been used. And I think now you can see that the representation has moved from being a fence post to being very much a signpost. Because to know what colour is relevant, you have to go outside the register, which is just for black and white marks, and into the marketplace and investigate how the mark has been used by the trademark holder. Now, there are limits to the Specsavers doctrine, at least in the views of the English and Welsh Court of Appeal. The English and Welsh Court of Appeal rejected the view that Specsavers actually required all sorts of other material to be brought into consideration in an infringement analysis. So in this case, the claimant was Scrabble and had the mark Scrabble for board games. And the defendant had a game called Scrabble with Friends. And the claimants argued that in considering whether there was infringement, you had to consider not just the mark as registered, but the fact that it had been marketed in relation to games that were in tile form, with numbers on them, with notions such as premium word scores, triple word scores, double word scores, etc., and in association with a woodland green, a dark green background colour. And their submission was that if some attributes appeared routinely and uniformly in association with the mark, it should be taken into account. And the Court of Appeal rejected that. The Court of Appeal said, no, we look outside the register to see how the mark on the register is perceived through its use in practice. But that doesn't send us on a journey to explore all sorts of other potential trademarks or attributes that lie beyond the mark itself. So at least in the English court's view, and we don't yet have the Court of Justice opinion, there are limits to the extent to which the Specsavers doctrine sends you on a complete journey. It's a signpost, but it's not a signpost that allows you to incorporate anything into the analysis. The same points can be made in relation to Article 9.2c. And I think here it is even more obvious that the register is just a starting point and not an end point, because 9.2c seeks to protect not just the distinctive character of the mark, but the reputation associated with it. And it's protecting that reputation against free riding, taking of unfair advantage, or detriment through tarnishment. But in various parts of the case law, you see the Court of Justice again indicating that it's not merely the mark on the register that is of relevance. Other things, such as distinctive character and repute acquired through use, are important. So, for example, in Intel, the Court of Justice says the existence of a link between the marks at issue must be assessed globally, taking into account all factors relevant, including the strength of the earlier mark's reputation, something that's not on the register, and the degree of distinctive character acquired through use. And in relation to damage, in L'Oreal, the Court of Justice indicates that the stronger the mark's distinctive character and reputation, the easier it is to establish detriment. So in both these respects, during infringement analysis, the register stops operating as fence posts and starts to function in a different way as signposts. Now, I'd like to suggest that I am the first person to come up with this idea, analysis, but I'm not. So as long ago as 2003, when considering the case law on exotic marks, Robert Burrell and Michael Handler made precisely this point. Although at some level, they said, it is clearly true to say that a requirement of graphic representation performs a definitional function, the ECJ's assertion that it is the representation of the sign on the register that determines the scope of the property is deeply problematic. The success of the bureaucratic enclosure of trademarks, they say, is illusory. There is pressure at all times to look behind the register. So, that's the basic thesis. And then the next questions are, what are we to make of it? we see on the one hand a fence post model, and then we see later on a signpost model. We see an inherent discontinuity in the system. We see an incoherence or seeming lack of logic. So we need to try and figure out a way to understand it and make sense of it. And it strikes me that there are two ways, and I'm going to elaborate on them. The first is to see the fence post model as concerned not with the extent of protection, but just with the subject matter. And the signposts coming in at the subject matter point. And although that may seem, fence post at subject matter, signpost at extent of protection, and although that may seem a little incoherent, I think we can argue that it has some justifications. The second, and the argument that I'm really going to push, is that in fact this reveals the fact that we have two trademark systems merged into one. We have a trademark system that protects unused marks and a trademark system that protects used marks. And the Court of Justice wants to give a different sort of protection to the trademarks that have been used than it wants to give to the unused marks. So with the unused marks, the register is indeed fence posts, but with the used marks, the register functions only as signposts. So, let me first of all just try with the basic analysis of subject matter versus scope of protection. Excuse me 1 minute. Okay, so the argument here is that the thing that I've presented as a discontinuity is not actually a discontinuity. It is a part of the system that is in some ways inevitable and not necessarily in any way undesirable. We require precision and certainty at the subject matter stage, though we recognise there cannot be that precision and certainty at the scope stage. Why? Well, firstly, at the subject matter stage, the offices have jobs to do that require clarity and precision and certainty, that are jobs that are not important at the scope stage. And some of those jobs are really boring procedural sides of trademark law, matter to trademark attorneys, but not much to academics. So offices have to decide, for example, priority matters or seniority matters with regard to trademarks. So a trademark applicant may apply to the EU Trademark Office but claim priority based on an earlier Paris Convention application in another country. And the office has to be able to determine whether the earlier application is identical to the later application. Now, in determining a question of identity, you can see that the office is going to want a high level of clarity and precision in the determination of what the subject matter of the mark is. And it is exactly that same standard identity that applies in relation to seniority claims. So seniority claims are claims made at the EU Trademark Office that the mark builds on prior national marks, and the national marks get subsumed in a successful seniority application. The national marks get subsumed into the community EU trademark registration, so that the person who continues the EU trademark registration that has claimed successfully seniority no longer has to maintain their national marks. And the protection afforded by those national marks is automatically folded into the EU trademark registration. In seniority applications, just as with priority applications, the EU office has to assess identity between the marks. And that notion of identity, as I said a moment ago, obviously requires some level of clarity and precision. Secondly, if we want the trademark system to provide as much information as possible, it might be that we accept that we cannot have clarity and precision as to scope. Why? Because the way in which marks are actually going to get used in practice must vary because of commercial considerations. So you might register in one form, but you might want to use a slight modification or variant in another form, etc. So there is an extent to which marks as used inevitably vary from marks as registered. And we would want to give protection that took into account how the variant had been used, not just the registration itself. So while we might accept that having certainty as to scope is impossible, we might think having certainty at the subject matter level is still a very desirable thing because it's the starting point for determining scope. So if we can have certainty at that point, and we can have that certainty cheaply, then we should try and achieve that goal. So those are the reasons why we might think that in fact what I presented as a discontinuity, fence posts at subject matter, signposts at scope of protection, is in fact an ideal compromise within the system. And indeed, we find that distinction recognised at various points. So in this general court decision on seniority, Medinet, we see precisely this distinction between a comparison of the elements comprising the mark necessary to judge the seniority application is different from a determination of scope of protection, which requires a more wide-ranging trip into the marketplace and outside the register. So these arguments, to some extent, suggest that the discontinuity is not altogether a problem. But I want to suggest at least 2 points that make me feel uncomfortable still about the discontinuity. And the first is that many of those statements I presented to you about why the law requires clarity and precision don't just refer to the needs of the trademark offices. They very much emphasize the needs of third parties. And it strikes me that we can say this discontinuity isn't a problem because trademark offices have some other jobs to do. But we can't maintain that it's not a problem if we really think seriously that the register is supposed to give very valuable information to third parties about what they can and can't do. The second reason why I'm not happy with this way of massaging this, what I've described as a discontinuity, is that in some of these doctrines, the external trip to the marketplace seems in fact to change the very nature of the subject matter. The subject matter, not just the scope, is changed by the Specsavers decision, in my view. The subject matter is changed by a requirement that we look to the marketplace to determine what is the distinctive character of the sign as registered. So a good example of this would be the practices relating to disclaimers. It might be that you had in your trademark application, you are allowed to under the directive, so some member states allow for disclaimers, and the EU used to allow for disclaimers at the application stage. And disclaimers could be useful to make sure that it was clear that your trademark application was not intended to give a monopoly over some elements which were non-distinctive or descriptive. Now, when the that trademark with the disclaimer goes into the marketplace, it is quite conceivable that those elements can acquire distinctive character through use. We all know that through use, elements which are descriptive or non-distinctive can become distinctive. That's the basic principle in Article 7.3 of the regulation. So that seems to highlight to me that whatever your views may be about property definition, the emphasis on the development of distinctive character in the marketplace as part of the scope of protection analysis, in fact, is changing the subject matter of protection as well. If, however, you are persuaded that the discontinuity that I presented is not that much of a problem, it might be that you can draw some conclusions from it. And one conclusion might be that the Court of Justice has rather overemphasized clarity and precision. And we don't need to be quite so rigorous about notions of clarity and precision as they have been. And Curley makes a point in the new edition: the requirements that the sign must be precisely identified and graphical representation must be precise and unequivocal are capable of being taken too far. The underlying policy does not require that every mark be registered with absolute precision. But as I've said, I don't really accept that there isn't a significant discontinuity lurking here. I don't think that it quite works for me to say we need certainty at the subject matter stage, even though we'll accept large levels of other investigations are necessary to determine scope at the later stage of determining whether there's infringement. So I want to suggest to you that what's going on here really is that we have two trademark systems. And this is really where this talk is driving. There are two parallel but overlapping regimes. One regime that protects unused trademarks, where the register defines the property, and it defines it using a fence post model operable for the 5-year grace period. So you have this, the only thing is the register. You look at the register to determine the scope, you look at the register to determine the goods or services, etc. And then we have a system of protection of used marks where the register operates as a signpost. It signals that that property is claimed, but it does not determine the extent or scope, what is covered, because it can't, because to determine what ought to be protected in a used mark involves necessarily a trip outside the register and into the marketplace. So firstly, with regard to unused marks, the system operates to provide notice that marketing space is reserved for the trademark registrant, that is a space that they want for themselves and that they may enter within the 5-year period. Now that exclusivity is being given just in return for money. Somebody proposes a plausible mark, a mark that would be distinctive if used, etc. They're paying effectively for a little bit of the marketing spectrum for 5 years. And of course, it seems to me absolutely right that in circumstances where we are giving away exclusive rights in return for money, that the extent of the space that's being given away needs to be defined clearly and precisely. It wouldn't be good enough to say oh, that person has paid some money and claims some space in that general area. In contrast, for used marks, it seems to be rather odd that we would think that the registration ought to define precisely the scope of protection. Think about the protection that is given to used marks outside the registration system. Outside the registration system, used trademarks that acquire a reputation in the marketplace get protection under all legal systems, in the common law through passing off, in civil law countries often through laws of unfair competition. And these give protection to the trader from having other traders misrepresent their goods or services by using those marks. Here, the notice function comes from the expectation that other traders should search the marketplace before launching their products. There is no register, so the notice is provided by the expectation that third-party traders actually search and find out what's out there. The use by a particular trader in the marketplace gives no indication of the extent of protection. Whether something is covered or not will depend on how much reputation that person has built up, what the reputation is for, precisely what the defendant is doing. So my starting point here is in relation to used marks to ask the question, how could we think that the registration system would effectively provide more information when the marketplace itself is not able to provide any clear information? And that leads me to see the registration system in relation to used marks as merely a notice system that rights are claimed in that area, not as an appropriate mechanism to define the rights. And I think we see that the Court of Justice accepts this in the flexible way it applies the law on maintenance of registered marks. So if a mark has been registered, that mark can be maintained on the register by use of a different mark, where that different mark only varies in a manner that doesn't alter the distinctive character of the registration. And the Court of Justice has told us in numerous cases, including Rintish, that the idea is to allow the trader to utilise variants to update their mark in response to changing marketing and promotion situations. And in practice, the court shows a great deal of flexibility in what it treats as an appropriate, what it treats as counting as a use that doesn't alter the distinctive character of the mark. And this is just one example. And you'll see on the left a registration for bugweed with an orange. And this is the mark as registered. Seems rather odd, but that's what the case says. And this is the mark that was used by the trader. And you can see that this mark is quite different from the mark as registered. Startlingly different, one might say. Nevertheless, the General Court agreed that this was a use of a mark that didn't alter the distinctive character of the mark as registered, and therefore could maintain the mark as registered. So it involves a heavy emphasis on the word bugweed in the mark as registered and the use of the same bugweed in these marks, and it involves playing down very much the figurative elements in the two marks. But the point I want to make is that this, to me, supports my view that the trademark register is being understood as a signpost, not a fence post. it's being understood as a system that links and identifies that marks are protected, but takes a very, very flexible view in determining what those, the content of those marks are. So I need to wind up. I think I've been going on much too long. What are the implications of this? Well, I would say one implication is that we could start to recognize a bifurcation in the system. We could recognize different standards for unused marks than for used marks. And indeed, these could be different standards at the point of registration. One possibility would be to allow, at the point of registration, a much more flexible representation requirement for a mark that had been in the marketplace and acquired distinctive character than would be the case with an unused mark. And this was proposed and rejected, I should say, in Mattel and Zynga. In Mattel and Zynga, which is the Scrabble case, there was a registration that looked like this, and it described the registration. The mark consists of a three-dimensional ivory-coloured tile, on the top surface of which is shown a letter of the Roman alphabet and a numeral in the range of 1 to 10. Now, we all know this is Scrabble. Okay. And what I would suggest is that it might be that we would allow a broad representation like this because we know this has acquired distinctive character in the marketplace. And because with registered marks, we're not treating the register as determining the fence post, but really as a signpost to what's out there. So when we consider whether something is confusingly similar under the Specsavers doctrine, we would precisely take into account that this is what the consumer was familiar with in relation to this registration. However, the Court of Appeal of England and Wales rejected that view. It said that you had to consider the representation by itself as if it was the fence posts. You had to decide whether it was clear and precise. And it wasn't clear and precise because in its terms, it could cover these things. Now, I'm saying I think that might be something we could revisit. Secondly, I think we could start to think about ways, if we saw trademark registration as signposts, to improve the information that signposts provided. There are certain things that thinking about trademark registrations as fence posts limits us from doing. So one is that we don't have amendment of trademarks. You can apply to register your trademark, but you can't amend it. So this is very different from the patent system, which allows amendments and both of the specification and claims as long as they don't add matter. But given that trademarks vary over the period of the life of a product, they get changed and altered. If we saw the trademark register as a signal rather than as a property defining thing, then we could encourage trademark proprietors to register the new variants as amendments to the old marks. And that would provide more information to third parties than is currently being provided by the register, where somebody keeps the old mark and relies on the kind of buggery situation to justify maintenance of the old mark. And we could then start to think of mechanisms to incentivize those amendments to get people to replace the old forms with the updated versions. And thirdly, if we recognize bifurcation, I think we would then need to think much more carefully about what the relationship was between the registration of unused marks and the registration of used marks, and in particular the 5 years grace period. Should somebody who has a used mark also get a 5-year grace period for whatever is registered? And should the use be regarded as only ever increasing the trademark proprietor's rights over that which is granted to an unused mark from registration? And that's something that I think nobody has really been thinking about. So finally, and to conclude, and I've gone on too long, I'm afraid, the thesis of the talk is this: that we want to know whether the trademark representations function as fence posts or signposts. And this seems to be linked in some part to whether we care about the register as a self-referential system or whether we care about marketplace reality. And I've suggested that the Court of Justice seems to care about marketplace reality. And so where marks have been used, it seems to abandon the idea of the register as a self-referential, self-contained system. And therefore, it's abandoned the fence post model of representation. One way we could respond to this, I suggest, is to recognize a bifurcation within the system. But there is another way we could respond, and that would be to harmonize the protection of used marks through unfair competition law, and then leave the registration system to do a distinct job from unfair competition law. And one of the things that's forcing the Court of Justice into focusing on marketplace reality is that we don't have a harmonized system of unfair competition law in the EU now. And with that thought, I will conclude and happily take any questions.